I'll just note our last sidebar, 245, was counsel basically discussing with the court the fact that what I just told the jury about some additional evidence tomorrow morning and then potentially state's rebuttal case tomorrow morning. And the state indicated it would be fairly brief. Anything further either counsel would like to say about the last 245 sidebar?
No, Judge.
All right. At 217, there's a sidebar, and it really wasn't an objection on the table, I don't believe, but it was somewhat of a discussion about the exhibit involving the pages from the DSM-5, and we may have to take that up at a later time, but
So I do want to just, because I want to make sure it's fresh on my mind, Judge, I approached, I said I had no objection to the state's use of Exhibit 720, the 9 pages of the DSM-5, as use on cross-examination. Mr. Hahn and I had previously discussed it would not go back to the jury as a piece of evidence. I approached to look for clarification on whether it could be used as substantive evidence in argument, in closing. Mr. Hahn, I think, pointed out a 90803 sub 18, how it's admissible based upon Dr. Hopper's acknowledgement on cross-examination that the DSM-5 is a recognized authority in the field. During that sidebar, I essentially conceded that point. I did concede the point. It wasn't anything.
Is that tough for you?
It is. It's very difficult for me. I conceded that point. I imagine Mr. Hahn made tactical decisions based upon what I had said on the sidebar. After that, I came back and had a further discussion with Ms. Vishny. She is, in many matters, including all matters of the law, tends to have a much better understanding and grasp of it, and may have other arguments about maybe what I should have done or could have done. But I wanted to put on the record what I did do, and acknowledging that may have impacted Mr. Hahn. I'm trying to be as transparent as possible about that. So I did what I did. He did what he did based upon what I did. Whether Your Honor wants to take up Ms. Vishny's arguments now or later, I guess I'll defer to Your Honor. But I wanted to, while that was fresh in my mind, and I was willing to concede, which is sometimes difficult for me, I wanted to just do that.
okay. As far as I'm concerned, it's fresh in our mind. We're on that topic. Rather than risk forgetting to come back and clear it up, I'd like to address it then now.
I will defer to Ms. Vishny, who I think has, if she's, based on our previous discussion, still wanting to bring that up.
Well, Judge, wasn't at sidebar, so I'm not sure what exactly happened, but generally speaking, in terms of learned treatises and law of learned treatises.
Microphone, please.
I'm sorry.
Thank you.
This was not filed as a learned treatise by the state. The state certainly had noticed for a long time that Dr. Hopper was going to testify. That being said, it's entirely appropriate for the state to use the DSM or the portions of it in their cross-examination of Dr. Hopper. However, only the portions that have been used in the cross-examination are actually admitted into evidence in terms of the jury's knowledge. And the remainder of the learned treatise, what was not used by the state, should not be argued in closing arguments. And of course, the learned treatise should not go to the jury. The treatise itself is not to be received, quote unquote, except for impeachment on cross-examination of the witness unless the party offering the document provides the opposing counsel with the appropriate notice in State versus Kazee, K-A-Z-E-E, the court wrongfully, hold on a second, I better check and make sure this case is published. 1 minute. I didn't look at that. Oh, no, I'm sorry. I withdraw that citation because it's unpublished. But basically, the rule is that, the state can use whatever it wants on cross-examination of the witness, but if the witness hasn't had an opportunity to respond to something in the substance of that learned treatise, it can't be argued because it's not substantive evidence in the case unless it's been testified to. So I'm not really sure what happened in sidebar or what the agreements were. If certainly anything that Mr. Hahn cross-examined the witness about from the learned treatise, anything he read is fair game for closing argument. I wouldn't have any dispute with that whatsoever. And, there are cases that clearly say that, but not portions that weren't testified to.
All right, Mr. Hahn?
Just a second, Your Honor.
Just basically, error. Here's this. This is basically this section here. Diagnostic features of it. It's on the front. Yeah.
That's just the diagnostic features section. Here all the way.
I think they're seeing whether they can reach an agreement. Then I can say my part.
Judge, there's a two-page document, or there's 2 pages of the document that the state is proposing. It's going to take me a while to read through it, and so I don't know if you want to take it up again later today or tomorrow morning, but we might be able to agree, but I have to read these 2 pages.
Okay. Well, we'll take that up in the morning. Okay.
You want to finish all the sidebars and then I have a different issue.
All right.
Judge, on that same issue, just on Exhibit 720 briefly, there is a page 280, the bottom third of the page has an X through it. The parties had agreed that that essentially would be redacted regardless of what the decision on the admissibility is, so that it's not a complete redaction, but it wouldn't go to the jury. It wouldn't be argued. I think that's understood between the parties.
Agreed.
All right. All right, the only other sidebar I have in my notes then
Oh, I see.
involved when Dr. Thomas was testifying, and there was a sidebar with Ms. Nodoff and Ms. Vishny at 10:06. And there was, the objection was sustained and a rephrase of the question. I think we moved on. This was the area where Ms. Vishny was asking questions about whether, this going back and with further information, for doctors, does that also apply to emergency room doctors? And which again appeared to be a question related to, Dr. Tillotson, if he would have had this, that, or the other thing, maybe he would have changed his opinion type of an argumentative question. Again, the court sustained the objection and Ms. Vishny went at it just in a general way. And I think as far as the court's concerned, that was the end of that. But anything in addition that either counsel would like to say about that on the record?
No, I rephrased my question and
Okay.
that was fine.
And that's all I have for sidebars, unless council has any other moments that anyone would like to put on the record. You feel it should be noted?
Not from the state, Judge, thank you.
Okay, Mr. Nelson or Ms. Vishny?
Not about sidebars or anything else. If Ms. Vishny may have something else, but.
Okay,
Judge, we have requested that the state provide us with information, which they did, regarding the costs paid to the Ramsey County Medical Examiner's Office, which are inclusive of the autopsy, the doctor's fee for reviewing its final report, and the court fees charged by Dr. Mills. Ms. Nodolf has complied with that and given us a figure, which includes broken down each one of these matters, $1,647 and $500 together that was paid to the Sheriff's Department for the autopsy and the doctor's fee for reviewing the final report, Dr. Mills' court fees of approximately 8 hours and 11 minutes at $300 per hour at $2,455. When I spoke with Ms. Nodolf, she wasn't sure whether or not that funding goes to Dr. Mills or whether it's paid to the Ramsey County Medical Examiner's Office. So I drafted a proposed stipulation for the parties to Mr. DeFore, and I suggested that it would be stipulated by the below-listed parties that Dunn County paid approximately $4,600, because the number's 4602, the following fees for the autopsy, lab testing, final report, testimony, preparation, and in-court testimony, including Dr. Mills' $300 billing rate in connection with the death of Alex Woodworth and the case of State of Wisconsin versus Ezra and McCandless. My proposed stipulation does not include anything regarding who the payments were to, because when I talked to Ms. Nodolf, she didn't know, so I was not able to put that in. Mr. DeFore emailed me back stating the following: we would not agree to a stipulation on this. First,
And counsel, as far as, and maybe I missed.
May I finish, please?
Yeah, why don't you let Ms. Fuentes
I just want to say that I may have misspoken as far as whether or not the money was paid to Dr. Mills. I assumed it wasn't, and I may have been wrong on that.
I have no idea. But in any event, what Mr. DeFore ultimately wrote, I'll skip the sentence about who paid because that's not relevant. Mr. Mills, let me just say this. Mr. DeFore's bottom line was, we are frankly not willing to stipulate to anything on this area. So we're searching for the bills right now, but I don't know if we're going to be able to get them on time. But what I'm going to do is ask that the court take judicial notice of the fact that Dunn County has paid approximately $4,600 for the autopsy, doctor's fees, including consultation with the prosecutor's office and testimony. And looking at section 90201, judicial notice of adjudicated facts, the kinds of facts have to be one not subject to reasonable dispute, that is any of the following. Clearly, this is not sub A, a fact generally known within the territorial jurisdiction of the trial court, because it's not. However, sub B says, a fact capable of accurate and ready determination by resort to sources whose accuracy cannot reasonably be questioned. I don't think that Ms. Nodolf's accuracy can reasonably be questioned. Since we don't know who paid the doctor, I would ask the court to take judicial notice with just saying that Dunn County has paid these fees, as opposed to whether the recipient of the fees is the Ramsey County Medical Examiner's Office or Dr. Mills. Frankly, that doesn't make any, frankly, we just want the truth to come out. And though I'm rather stunned that Mr. DeFore and the Attorney General's office would not be in favor of the truth being elicited in this matter, it is, I think, the truth. I think $4,600 be an approximate amount, and I don't know who actually got paid the fee. But I think there's a potential misimpression here with the jurors, and this is, according to 90201 sub 2B, appropriate, and it also says that judicial notice is mandatory. Under sub 4, a judge or court shall take judicial notice if requested by a party and supplied with the necessary information, which I believe we have done so. There's no opportunity, this amount is not disputable since it was provided by counsel. So I would ask that the court do the following when the jury returns in the morning.
All right, state wish to be heard.
Yes, Your Honor. First off, while the court is, counsel reads those sections correctly, The first section of that, sub 1, states scope. This section governs only judicial notice of adjudicative facts. In other words, facts that are relevant. And frankly, Your Honor, if the money was, assuming, and I don't have any reason to dispute that it's approximately $4,600 that was paid to the Ramsey County Medical Examiner's Office, I don't see how that is relevant to any issue at stake in this trial. It is not relevant towards Dr. Mills' credibility because Dr. Mills is not paid that money. The Ramsey County Medical Examiner's Office is paid that money. At least that's all that we know for sure. I mean, oh, sure. And if Ms. Noto has a different information.
Yep, after lunch I had my staff follow up. So the first portion that is paid by the sheriff's office, I just want to clarify, I don't know if they've been paid. This is just what the Ramsey County office said was the bill for performing the autopsy and then the $500 fee. The 8 hours in court, she gets paid $300 an hour, and we received confirmed information that that goes to Dr. Mills. So, you know, if anything is relevant, I would think it would be the cost of Dr. Mills to testify, not the cost of performing an autopsy, just like we don't ask officers how much did you get paid to show up and do your job that day.
All right, if that money is paid directly to Dr. Mills, then I believe it is potentially relevant, and that, you know, I guess there is a basis for taking judicial notice of it at this point in time. So I don't have a problem with that portion, but not the other portion. That would make it approximately $2,455 was paid to Dr. Mills in connection to or for the time spent in testifying at trial.
Yes, I think that the appropriate amount of, first of all, I agree with the amount, $2,455, because that's what Ms. Nodolph put down. And second of all, what I would ask is that the court take judicial notice that Dr. Mills was paid at the rate of $300 per hour for approximately 8 hours and 11 minutes of her time in preparation for and testifying.
And travel time.
Yes, well, yes, travel time is part of it, of course, is for both parties. So, in other words, apparently, and that does not include the fees for the autopsy itself. So, but rather, this is her fee. So, that's what I'm asking the court to do, since the state doesn't want to stipulate.
All right, very well, then we'll, that portion that, it sounds like undisputed in terms of Dr. Mills, and so court will do that tomorrow. I would appreciate being reminded to do that, but I'll try to remember.
Judge, I can send you an email. I don't know if I send it to who do I send it to exactly?
Well,
Obviously, I would copy all parties.
yeah, why don't you send it to the judicial assistant?
Okay, I'll get that from your clerk. Okay, thank you.
Okay, anything else today, council? All right, any additional jury instruction, submissions, requests?
Your Honor, we've submitted a modified McMorris instruction. Ms. Vishny asked for a Word version of it, which we have now provided her. But we did submit that. It came in this morning. It should have come in earlier today. I'm not sure. I saw the e-filing notice probably about an hour ago, but I'm not sure exactly when it actually came in. But we have submitted that. We had discussed that yesterday.
All right, can you also give well, let's go back to something. I know we have to clean up. We have two exhibits, 655. And we have to, one way or another, change the exhibit numbers.
I assume they're not just a full version or redacted version of something. They are actually two
different
totally
things,
different
yeah.
things. All right.
And the Madam Clerk has them. I believe one was a document that, maybe, why don't we just have you take a look at it? Okay, then, may I see those? And then I'll,
Okay, so,
okay. All right, so just for the record, for the, the transcript here, I'll just indicate that there was a property inventory record from the Dunn County Sheriff's Office, in the case recovered by Brett Conkey, that had been marked exhibit number 655. It also has DOJ 400 written on the bottom margin. And it's kind of a green, must have been a green piece of paper with a color copy. And it specifically related to the clothing of Ezra McCandless that was, I believe, either recovered from, it's just obtained from the Eau Claire Police Department. So it's a property inventory record that it was, again, previously Exhibit 655 and received as such, and that will be changed to Exhibit 721, and then, again, it's still part of the record, but just be a different exhibit number. The other Exhibit 655 was a copy of a Wisconsin State Crime Laboratory, Wausau, receipt of physical evidence, and that will remain 655, and that was signed, it's a photocopy of this document signed by Carissa Wobler. Anything either party would like to say further in the record regarding those two exhibits? Okay.
Thank you.
Okay, thank you. Mr. Nelson?
Complicated, I just think, what's the new number, 721?
Yep, 721 would be the
Exhibit 721 is a page from a previous exhibit that was admitted during Jason Stalker's testimony as well. So again, I don't know if that just complicates the matter, but I understand it's a separate document, but it also might be one page out of a 14-page document that I can't figure out the number of that was admitted as part of Stalker. So I just think the page was admitted twice, which is fine.
Okay.
So if there's confusion later as to why there's a duplication, it's not because of this. It's just I admitted it once and then the state admitted it later as a part of a bigger package.
Okay. All right. Ms. Vista, you have that look like you have something
I
to say.
have that look. We're going to do the jury instruction conference tomorrow, right?
Yes.
Okay. I think it would be advisable, even though we haven't submitted our written jury instructions, for it just to give the court a heads up
Yes.
as to where we're going. So that gives you some time to think about what our proposed instruction is. I believe the state has submitted its proposed substantive instruction, and we're just cleaning up some language as ours. But just so the court knows, the lesser includeds that we're asking for are both second-degree intentional homicide as it pertains to imperfect self-defense and first-degree reckless homicide. Those are also being requested by the state. The defense is also requesting second-degree reckless homicide and homicide by negligent handling of a dangerous weapon. So we'll submit something in writing, and I'm sure we'll do arguments tomorrow. I'm also want to advise the court, and I can give you some citations in support of this. About another modification to the instruction. 1 minute, I'm sorry. But I just want everybody to have a chance to look at this. And I apologize for the fact that this is taking kind of a long time because I'm trying to find the email that has this. I'm sorry.
Why don't we go off the record for a minute?
Okay,
Well, no, unless
sure.
there's something else, someone else.
Yeah, I was just going to say, if Ms. Mitch is okay with it while she's looking for what she's looking for, just to advise that while the state submitted first-degree reckless homicide based on the testimony, we are withdrawing that request. I understand the defense likely will be requesting it, but we are not going to be requesting first-degree reckless homicide. We do agree that there is sufficient testimony to support the second-degree intentional, but we don't believe the testimony supports first-degree reckless. Obviously, we can argue that tomorrow, but I just wanted to make sure the council was aware of that so they're prepared for that tomorrow.
All
That's
right,
fine.
well, and again, the court's mindful that by rule, I guess every lesser form of homicide is a lesser included offense of a greater form of homicide. However, if there's any authority as it relates to whether the court actually gives those instructions that you wish to have the court review, do you have any citations with respect to that, or? And again, I'm just looking for the appropriate standard the court should consider.
Well, here, I can tell you what the standard is. Just give me your computer. We were preparing something in writing, but let me just advise the court that a criminal defendant is entitled to a lesser included offense instruction if requested when reasonable grounds exist in the evidence both for an acquittal on the greater offense and conviction on the lesser offense. And I'm citing to, this is published, right? Okay, just make sure. State v. Miller, and the Wisconsin second citation is 320 Wis. 2nd, 724. Or stated differently, the lesser included offense should be submitted if there is a reasonable doubt as to some particular element in the higher degree of the crime. I mean, I can keep citing cases, Judge, if you'd like me to.
Well, I mean, what I just want to know is just the appropriate standard.
That's the standard.
Okay.
And, you know, that's clearly a 2009 case. The standard has existed for a lengthy period of time. I don't think the state would dispute that that's the standard, though the state may want to cite other cases in support of its argument. I'm certainly not going to not say that, but I'm also, there's something else that's where we're going to deviate from our drafted jury instruction. And we are going to ask that the charge of self-defense should be tailored to the circumstances of our case, and that therefore that the language where it says reasonable person should become reasonable woman. I will advise the court that in the case of State of Wisconsin versus Corey Klaser, Kleser, now Corey Klaser is well known as a Wisconsin Supreme Court case that has to do with reverse waivers and what expert witnesses can testify to. That was on an interlocutory appeal because it was a juvenile reverse waiver case. The Corey Klaser case was tried in Milwaukee County, and Mr. Klaser was a juvenile when he killed, and in fact it was sharp force injuries, an older man who he said had attacked him sexually. Mr. Klaser himself used to undress for money in front of men when he was about 14 years old. By the time the case came to trial, Mr. Klaser was older. I believe he was probably an adult at the time he came to trial, but he was either 14 or 15 at the time that the offense was committed. And at trial, Judge Richard Sankovitz from the Milwaukee County Circuit Court agreed with the defense and provided the jury with an instruction that in the self-defense instruction that the jury should consider the reasonable juvenile based on the testimony that had occurred in the court. It's our position that because women and men are different in terms of their physical abilities and because of the experiences of women, that this would be appropriate to tailor this jury instruction to the circumstances of our case and use the phrase reasonable woman. I am not aware of any supporting case law for this in the state of Wisconsin. However, I will cite two cases. One is State v. Wanrow, W-A-N-R-O-W, at, it's Washington State. Do you want the Pacific Second citation, Judge?
Sure.
That would be 559 P. Second, 548, 1977. The
Sorry,
Washington,
what was the page number again, counsel?
548.
548,
Yes.
thank you.
In that case, the Washington Supreme Court recognized that its traditional self-defense standard failed to account from the perspective of abused women. Any limitation of the jury's consideration of the surrounding acts and circumstances to those occurred at or immediately before the killing would be an erroneous statement of the applicable law. Another case that, well, I think that's the main case. But that is a slight language change to reasonable woman. We're not asking for something like reasonable alleged sexual assault victim or reasonable abused person, but just woman, to reflect the fact that Ms. McCandless is a woman and that should be taken into consideration rather than having gender neutral language.
But wouldn't that be the circumstances? I mean, the instruction discusses under the, circumstances as they existed at the time from the perspective of the defendant. And wouldn't that be one of those circumstances?
I certainly think that's implied, but that the use of woman in the language would make it more explicit and better conform to the evidence in this case.
All right, is state prepared to address that at this time?
I'm not prepared to address it at this point in time, although I generally share the court's view that I think under the circumstances, it's already covered there. There are a couple cases that the court may want to take a look at as it relates to lesser includeds as well, including State versus Morgan, M-O-R-G-A-N, which is 195 West 2nd, 388, 536 Northwest 2nd, 425, a 1995 Court of Appeals decision which discusses specifically when first-degree reckless homicide is appropriate, not appropriate. In that case, they affirmed they found that the trial court had instructed on first-degree intentional and not on first-degree reckless, but had included a felony murder one. And
I'm sorry, counsel, is that 195 was second 388?
388, yes.
Okay.
So you may want to, it goes through the analysis, and I think is a good analysis of when you should and when it's required and when it's not required to give a lesser included offense instruction. You may also want to take a look at State versus Weeks, W-E-E-K-S, which is 165 West 2nd, 200, 477 Northwest 2nd, 642, a 1991 Court of Appeals decision, which again goes through the criteria. I think the criteria are pretty standard in all the cases, and I think it's pretty much the same criteria the council mentioned, and that's essentially whether or not there is sufficient evidence to find not guilty on the greater offense and sufficient evidence to find guilt on the lesser offense. So I think it's appropriate to argue it tomorrow. I think those cases are ones that'll be pretty good for the court to start with and just try to get the basic framework for how you make that analysis.
All right, another area that I would like some input on is, I think the state submitted an instruction about the use of the mental health or evidence in this case. Was that the state? May have been, I'm not sure.
Yes.
Okay.
I think we did. We submitted an instruction related to that. Yes, Your Honor.
All right, and I think it was the way that it was tailored was as to explanations for the defendant's recollection and so on and so forth.
Just the same thing.
I wonder, again, whether, and I think we've talked about this at some other point in this case, whether that mental health, mental psychological evidence could the jury consider that as to the reasonableness of her perception or use of force as it relates to any mitigation from first-degree intentional homicide to second-degree intentional homicide. Again, for me, it comes from essentially what was the discussion from State versus Deborah Head, and that discussion was, I think, an Attorney General's letter or discussion before the 1988 homicide revision, and I don't know what the defense perspective is on that, and I don't believe there's any. I haven't seen any cases right on point with that, but that being discussed in State versus Deborah Head, it may just be dicta, but that's one issue I'd like counsel to think about. The second, yes, go ahead.
I haven't seen it, but there's been testimony today through a witness, Dr. Hopper, that talked about reflexes and habits when under attack, when the brain's under attack, and what happens to the prefrontal cortex and regarding behavior. And there was no objection, there was no limiting instruction, there was nothing that would suggest that they couldn't consider it for whatever purposes they wanted to. So the defense would be of the position that I don't have the instruction in front of me, but that at least as to Dr. Hopper's testimony today, that's something that the jury can consider in deciding reasonableness of the beliefs.
Well, I think this testimony said something along the lines of, misappraising the threat or misappraising the situation, something along those lines.
He also said, regardless of misappraising, he just said when the brain is under the attack, the prefrontal cortex is diminished and incapacitated, and so anyone in that situation, short of essentially a Navy SEAL who's got training, would respond in a reflexive or habit way. And so I think it cuts both ways, but it's certainly from the defense standpoint, that's what we're focusing on, is the reasonableness then of a belief under those circumstances at that time. And that's testimony about reason, how the prefrontal cortex is diminished. So again, we think it's, we would object to that, to an instruction that would limit the use of that evidence.
Okay, well, the big concern I have, of course, is that, the jury is not instructed that this is not a insanity defense, not an NGI case. I think in a way that they understand that, because the jury doesn't get that instruction, and they start thinking about some of this, I guess, for lack of a better term, psychological evidence. I don't want them to be confused and to think that that's on the table, so I think they should, I think in the instruction, and I don't know that there's a pattern for this, there is, again, if you get into that, but we don't have that plea, and I think a jury has to be told that, that's not an issue in this case in some way or another, so I'd ask counsel to think about that as well. Sometimes when juries aren't told about that, they take it upon themselves, but I think we do have an awful lot to talk about during jury instruction conference. So, anything else, again, today that the court, you want, give the court a heads up on?
Just when the court looks at State v. Morgan, Judge, I'm going to ask the court to think about this language. State v. Morgan, that's another case that I saw some of the trial of, took place in Milwaukee County. It was a rather famous case because Felicia Morgan, who I think was a juvenile at the time, had committed an armed robbery and had shot the victim. And the main lesson of the Morgan case actually has to do with things that have nothing to do with jury instructions. But what the court noted when it declined to give a first-degree reckless homicide lesser included instruction was that, number one, Ms. Morgan had shot the decedent at very close range, and that the trajectory of the bullet passed through the decedent's vital areas, and that it was almost touching the decedent's body. And, you know, here, the medical evidence, clearly indicates that these are wounds that were potentially survivable. They're at any particular, first of all, they could have been survived with medical treatment. There's testimony in the record as to that. Second of all, there's testimony in the record that Mr. Woodworth could have lived for some period of time, whether it was minutes to 30 minutes. I think that's the range that has been established, even though he ultimately bled to death. But there was not a stab wound, for example, to the heart or cutting the aorta that would clearly establish a lack of recklessness. That's on the objective side. On the subjective side, we have testimony in the record that not only goes to the issue of self-defense, where we have testimony in the record that not only goes to self-defense, that Ms. McCandless testified to, we also have both her testimony on the stand that she stabbed anywhere and everywhere she could. That's also in her statement to Detective Prock. She was also questioned on the stand whether she had an intent to kill. She said she did not. She was also told when she was interrogated, and that's in Exhibit 290, she was asked, and the state put this in, were you trying to kill him? And she said, I just wanted him to go away. He wouldn't go away. So there's pretty clear evidence to support a lesser included of first-degree reckless homicide and the line of reckless homicides as opposed to simply the line of intentional homicides. So I do want the court to take that into consideration. I think it's better for us to put forth some argument now in support of that, and I'd ask the court to think about that. And I think this is a very weighty decision because the failure to give appropriate lessers is one of the most frequent reasons why verdicts are overturned. That and other crimes evidence, quite frankly, in terms of my discussions with appellate lawyers and what happens. So you know, we are also making arguments for lessers beyond first-degree reckless, and I'll argue those tomorrow. But just in terms of the notion of criminal recklessness as compared to criminal intent, there's clear evidence in the record that supports an acquittal on an intentional crime and a potential conviction on a reckless offense. And I frankly think it can be reversible error, and I don't use those words lightly, to fail to give an instruction that incorporates recklessness. I'll leave the rest for tomorrow.
Okay.
Your Honor, I didn't think we were arguing this today, and so
We're
I
not,
haven't
but
argued it.
you're
and
welcome to
I'm not going to argue it today. We can argue it tomorrow when it's appropriate to do so. But you know, our position is clearly different than Ms. Vishney's, and we clearly do not believe it would be a reversible error not to give that instruction. I'll leave it at that.
All right. Okay, anything else?
I don't think so. I just want to.
All right, then we'll be in recess until tomorrow at, I just asked council to be here 8:25, so we can have the jury in at 8:30. Fine, we'll continue. We're in recess. Thank you.
Thank you.